pleased to announce our final speaker of the evening, or of the day, I'm sorry. And I thank you again for being here today so we can learn about all these different ways Memphis has impacted the law. Daniel Kiel is a professor at the University of Memphis Cecil C. Humphrey School of Law, where he teaches and writes in the areas of race and education. Professor Kiel is a native Memphian, but ventured away from home to receive his BA in History from the University of Texas at Austin and his law degree from Harvard before returning to Memphis in 2005. Professor Kiel's writing has appeared in the Washington Post, USA Today, multiple local publications, and in various national law reviews and journals. In 2008, his in-depth study of the Memphis City Schools desegregation litigation was published in the University of Minnesota's Journal of Law and Inequality. Please join me in welcoming Professor Daniel Kiel.
Thank you, Stephanie. Stephanie, we can vouch that we're going to be getting additional CLE credit since I'm going to promise that I'm not going to end at 4:20 as was on the schedule, so just so everybody knows. When Stephanie asked me to present, this was way back, probably early fall, maybe even last year that we were talking about, we said, you'll do something on the schools. And I thought, okay, well, I can do something on the schools, but wouldn't it be nice if the day before the CLE, I could coordinate it so that the state legislature and the city council would both pass actions to make my presentation uber relevant. And as you see, that plan has worked. So here we are. My initial presentation was looking at sort of the dual school desegregations in Memphis City schools and Shelby County schools. And I am going to spend some time on that as well. But I'm going to try to go through it somewhat quickly in order to get to sort of what is on people's minds today, which is what on earth is going on with the public education in Memphis and Shelby County right now. Okay, so that's where we're going. So I'm going to, and I think it's relevant to talk about both things sort of in the same presentation because although they are not the same, there is very much echoes of the desegregation era in the conversations of today, and in addition, there are some similarities, but there are clearly also some differences. So I'm going to make a point to say what's similar and what's different between then and now. But first, let's talk about that. First thing, I think it was covered earlier this morning by Mike Cody. We had segregation in Memphis. Surprise, surprise. Here is some of the legal basis for that segregation. The state law made segregation in schools mandatory. It punished as a misdemeanor violations of the state segregation statute. In addition, the Memphis City Schools Charter, which maybe we've heard a little bit about recently, in its original form, mandated the separate instruction of African American and white children. We know on May 17th, 1954, that the Supreme Court hands down the Brown versus Board of Education, which essentially makes those laws, those previous things that I had up there, no longer legal, no longer constitutional. At that time in Memphis and Shelby County, we had essentially 4 school systems. We had the Memphis City Schools running a white system and an African American system, and we had the Shelby County Schools running a white system and an African American system. And when I say the Memphis City Schools and the Shelby County Schools, I want you to sort of try to remember that we're talking about 1954, not 2010. And so the Shelby County Schools are very, very different at that time, as are the Memphis City Schools, than they are today. It's a much more rural school district, and a little bit later we'll see just how much more rural it is. Tennessee's first desegregation happens in 1956 in East Tennessee. This is the case that sort of where the state court acknowledges that Brown trumps our state laws that mandate segregation. It was a situation in Clinton where they brought in National Guard troops, so it was sort of pre-Little Rock National Guard, but on a much smaller scale due to the sort of demographic numbers. The response after Roy versus Britain is legislation from the state legislature that sets up statewide a new system for student assignment. The old statute said you have to separate, you have to provide separate school systems for African American and white students. Now we get a new pupil assignment law. The pupil assignment law is race neutral. I've got up here some of the things that a school board could consider or could take into account in making student assignment decisions. It did not call for the changing of zones for schools. It just said there will be race neutral student assignment and race neutral transfers. And then the discretion on whether to grant a transfer application or not rests with the local school board, which, by the way, was entirely white at the time. And these are some of the things that they can take into account. You can see that some of the things, like possibility or threat of friction or discord among pupils or others, is saying it is well within the discretion of the school board if they think that something like Little Rock or something like Clinton, Tennessee is going to unfold, then they can use that as a reason to not grant a transfer that would desegregate a school. This is passed in 1957 in Memphis, as well as in Shelby County. There are no desegregating transfers granted. So there were applications by African American students to try to enter formerly all-white schools. None were granted. Same is the case in Shelby County. So this triggers what? A lawsuit. The lawsuit styled in Memphis is North Cross versus the Memphis City Schools Board of Education. It's filed in 1960, and sort of as a sign of some good faith, 13 transfer requests are granted for the 1961-62 school year. These 13 students entered 4 first graders, entered 4 formerly all-white Memphis City schools on September 30th, 1961. This was the desegregation of the sort of initial desegregation of the Memphis City schools. You can see at that time we had about 112,000 students in the Memphis City schools. That's more than we currently have in the Memphis City schools. It's about 53% white students and 46% African American students. So that's the one thing that's notable about the desegregation of the Memphis City schools is that the city didn't have come to a halt. The local NAACP, the local police, the media, all sort of cooperated, and in addition the school board, all cooperated in a way to sort of make this event a non-event. Make it so that we didn't have a situation where Memphis was put on the map as this symbol of racial discord in the same way that Little Rock had been 4 years earlier. And in many ways it was successful. It actually triggered a comment by President Kennedy at the time saying something like, Memphis and its desegregation of its schools reflects a credit on our country throughout the world. So this was a moment sort of admittedly very small progress, but progress with cooperation and without discord. I'm going to go through the Memphis City's desegregation history somewhat quickly, and you can sort of read up there. But it follows the same litigation path as many other school desegregation cases. It's unique in that it's our schools, right, in our community, but it's not sort of off the charts, strange or weird. It does trigger it makes its way up to the Supreme Court and triggers one decision from the Supreme Court. In a concurrence to that decision, the Chief Justice said something along the lines of, we really need to start thinking about how we're going to define desegregation and unitary status, but we can't now because Justice Marshall had to recuse himself from the case, so they didn't have the full Supreme Court on board, and so they saved that decision that was alluded to by the Chief Justice for the Swan versus Charlotte Mecklenburg decision, which came down in 1971 and is quite famous for saying something along the lines of busing is a permissible tool to use. SWAN is a big turning point in desegregation histories across the country. Some key things to note: 1966 is the last year that the Memphis City Schools has a white majority. So beginning then and continuing until today, the white numbers decline in the city schools. You heard already about the sanitation workers strike from Mike this morning. That's in 1968. In 1969, you have the NAACP organize a series of protests in which students are absent from school in order to protest the lack of black membership on the school board, despite the fact that the majority of students in the system are African American. And just to give a snapshot of the progress that had been accomplished by 1970, this is 16 years after Brown, 10 years after North Cross is filed. These two big ones, you know, this is probably a lot of information, but these two big ones here, those, there, those, this chart represents where the African American students in Memphis City schools are attending school in 1970. The biggest chunk is 100% black schools, so that's total segregation. The next biggest chunk is 95 to 99.9% black schools. That's pretty much total segregation. And then the next is 90 to 95% black schools, so that's pretty total segregation as well. So when you put all that together, you see it's still very much, despite being a 51% African American and 49% white school district, it's very much a segregated school system. 63 of the, or I guess 130 of the 155 schools are 90% plus single race, either white or black. And that's a common definition for we would call it a racially isolated rather than a segregated school. So it's a highly racially isolated system. The response to those realities, and in addition to the SWAN case, which puts busing on the map, is a movement towards busing in the Memphis City schools. And you see this implemented with two plans. Plan A, which was called for 13,000 students to be bused, and then Plan Z, which took effect sort of the following year, which called for 3 times that many students to be bused. Plan Z was so named not because there was a plan B, C, D, E, F, G. It was wishful thinking on the part of Judge McRae. He said something along the lines of, I hope that this will be the terminal plan to finally desegregate the Memphis City schools. What instead it was a plan that bused 39,000 students and led to a 20,000 student drop in white enrollment over a 1-year period. So the city school system, which had been 42% white, 1 year was 32% white the following year. And the white population has continued to decline since that time. Okay, so I'm going to stop there for Memphis and start looking at Shelby County Schools briefly. So Shelby County Schools is, at the same time, going through its own school desegregation lawsuit. It's Robinson versus Shelby County Board of Education. It is commenced in 1963. The school district is around 35,000 students, so significantly smaller than the city school district. And it in some ways tracks along with Memphis City Schools and many other desegregation plans across the country. The case bounces back and forth. There's plans that are okay for a little while, and then as the Supreme Court turns up what's required to achieve desegregation, those plans are thrown out and new plans are put in, and then the same thing continues to happen through 1971. The one difference is the initial plan in the Robinson case, or I guess not the initial plan, one of the key plans in the Robinson case calls for the student racial makeup of every